For admission, item number 1.
Yes, madam. Yes, what?
My lords, this is a tender process outcome which is a part heard matter, my lord.
Who will
It's a-
take it up? Let us do it serially. The PWD.
Yes, Your Lordship. Your Lordship, that is item number 2.
That's item number 2. Oh, that's item number 2. Oh, here's the item 1.
Yes, Your Lordship.
Okay, they put this item 1 page behind, so that's why. Okay. Yes, so you tell me. Now the first thing is that there was an earlier tender, correct?
Absolutely.
And that earlier tender date, what is the date of the earlier tender?
19th September 2025. Date of opening was 25th
No,
October.
no, the NIT.
NIT 19 September 2025.
19th September. Wait. 19th September 25. That was the respondent number 4 was the only bidder,
Yes, Your Lordship.
and it was non-responsive.
Yes, Your Lordship.
And so a fresh NIT was opened, and
Yes,
that was
To
opened.
increase competition, Your Lordship.
Huh?
To increase competition, Your Lordship, it was advised by the AG office that the tender be reopened.
So a fresh tender was issued on 6/11/25.
Absolutely.
Then it was a 2-bid process,
Yes, my lords.
and your tender was rejected
Yes.
on the ground that only one of the partners had signed the same.
Joint
And
venture.
joint venture, and not two, and the 2 others had not signed. So
Yeah.
your joint venture is made up of 3 partners,
Yes.
correct? Then joint venture is made up of 3 partners. Then and the tender was submitted in the name of what?
Zoram Venture.
Zoram.
Ventures.
Zoram
Lead partner.
Venture is the
Lead partner.
lead partner. So Zoram Venture is the lead partner. Of Zoram, what is the name?
Zoram Ventures, Your Lordship.
Ventures.
Ventures. So Zoram Ventures is the name of the lead partner only.
Yes. Yes.
So what is the joint venture name? It doesn't have a name.
No, my lords. It is being represented by the lead partner, my lords, Zoram Venture.
So the turnover of the partners that was all submitted
All submitted, yes.
by all 3.
Yes, my lords.
Individually, you all don't meet the criteria.
Absolutely, my lords.
So you all meet the criteria only when it is added up.
Yes.
Correct?
Yes, my lords.
So now your case is basically to the effect that in view of the judgment of the Supreme Court in this Maha Mineral mining,
Yes, my lords.
huh,
Yes, my lords.
where there is no requirement of where there is no specific clause for submission of a
Joint
venture agreement.
So it cannot be made a ground for
It cannot be made a ground for. It cannot be made a ground for
disqualification.
declaring them non-responsive.
Absolutely.
Only on that.
That's my whole case, my lords.
Yes, you were saying that the work is of importance. It's regarding electricity.
Yes, Your Lordship. Your Lordship.
It is what is the work?
Yes, Your Lordship. The balance of convenience actually is in favor of the state, and also, Your Lordship, a third party has already been created. And second, and most importantly, Your Lordship, if I may be allowed to mention that at the e-tender submission, the joint venture was only signed by Zoram Ventures, and that was a document which was submitted at the e-tender. Now,
At the time
of writ petition filing, suddenly the appellants submit the joint venture agreement signed
Duly
by
signed.
all. Yes, Your Lordship.
In the
This
writ petition.
itself, yes,
In
Your
the
Lordship.
writ
This
petition.
yes, Your Lordship. This
But
itself
not
is an
prior to
admission.
that.
Yes, Your Lordship. This itself is an admission.
Did you ask for clarification?
Your Lordship, if we ask for clarification, that would actually be favoritism,
have-
because it is a e-tender, Your Lordship. So there's a lock
It's a
deadline.
e-tender.
Yes, Your Lordship.
ma'am.
And also, Your Lordship, in the NIT itself, which is on page 37
Page
of
30
the writ appeal,
Page
sorry,
30
Your Lordship, 216 of the writ appeal.
Just a minute. 216. Yes, 216.
So, Your Lordship, in clause 6 states that an incomplete...
Clause 6?
Clause 6, Your Lordship.
There are two
Point number
numbers.
6.
There are 216 in the middle and there's one in the side. The side.
The side one.
The
Yes,
side
Your
one.
Lordship. It's the title is National
Just a
Open
minute.
Com-
Just a minute. 216. Yes. National Open Competitive.
Yes, Your Lordship. So in
Yes.
clause 6, it
Clause
talks
6.
about an incomplete and ambiguous and or conditional bid and or bid submitted late is liable to be ignored, summarily rejected. And also, Your Lordship, if I may also mention that in page number 225 of the writ appeal, regarding tenderers should submit the following along with their tenders. 225, Your Lordship.
225. Yes.
Your Lordship, in that, under Part 1, Para 1, it says that the complete annual reports together with audited statements of accounts of the companies, firms duly signed by charter accountants for last 3 years preceding the date of submission of the application. If the application is joint venture, audited statement of all the companies, firms should be submitted. So, Your Lordship, if they are a joint venture, how else, at the time of evaluation of the technical bid, how else would the committee evaluate their joint venture if it has not been signed by all the firms, Your Lordship? It could be a misrepresentation. We cannot assume.
No. Yeah. You see, the issue is not with the turnover statement made by them.
Yes, Your Lordship.
The issue is with the joint venture agreement that has not been signed.
Yes,
Correct?
Your Lordship.
So that is different. This does
Yes, Your
not
Lordship.
come-
That is why, Your Lordship, I would like to get back to my first argument, that the annexing of the signed joint venture by all parties in the writ petition is also an admission that it is a fundamental defective joint venture. Why would they feel the need?
So basically, you are saying, okay, assuming that they were not required to submit their joint venture agreement.
Yes, Your Lordship.
Since they have submitted it, it was your duty to look into to look whether it was a valid agreement or not.
Yes, Your Lordship. And also, Your Lordship, again, the annexing of these joint ventures, and I would like to emphasize, Your Lordship, it is actually an attempt to cover and manipulate in the subsequent pleadings, Your Lordship, because why would they feel the need to submit in the form of an annexure a joint venture which is signed by all parties, which was never submitted in the e-tender itself?
So there is no proof that at the time the appellant submitted the bid,
Yes,
that
Your
there
Lordship.
was an actual valid joint venture agreement.
Yes, Your Lordship. And also, if I may like to add, Your Lordship, in the writ petition copy, there is a joint venture agreement which was signed on 11th, 2025.
Where page?
Your Lordship, this is in the part of the writ petition. It has not been
Writ
annexed in the
petition
writ
copy is
appeal.
not here.
It is there, madam.
It is here.
Okay, yes. Your Lordship, it is on page number 347.
347 side.
Yes, of the writ petition, Your
I
Lordship.
know which number, on the side or in the middle.
Your Lordship, there's only the one in the middle. The numbering is only in the middle. In
No,
the
no,
writ
in
petition.
mine there are two copies, there are two numberings. One in the middle, one in the side. I've got here
Your
186,
Lordship,
365.
the writ petition which was I don't think they have attached the joint venture agreement in the writ appeal, because, Your Lordship,
We will call for it just now if it
Yes,
is not
Your
there.
My lord, it is there. Let me take you to that page, madam.
Yes, there, which page is it?
526, my lords.
526. Okay, this one, 526.
We do not have the copy, Your Lordship, for us.
526, the
Yes, Your
526 on
Lordship,
the
this is
side.
It is on 347, Your Lordship.
347 in the middle.
526 on the side.
That's what I said, there are
Yes,
two
yes, Your
numbers.
Lordship.
Please understand what we are saying.
Yes, Your Lordship. So, this joint venture was signed on the last day of submission of the bid. That is 11/11/2025.
11/11/25. Yes. 11/11/25. Okay.
So this goes to show that, Your Lordship, this is a defect, uncurable defect of their own.
And where is your signed copy of your signed? This is a signed copy.
Yes,
This
my lord.
526 has been signed by all three.
Yes.
Huh?
Yes, my lords.
No. It has been signed only by Zoram Ventures.
My lords, page 350 and 351, my lords. Oh, sorry, 529 and 530. My lords, actually during the uploading of our bid submission, we have partially uploaded our joint venture agreement. That was our defect, that we have not uploaded the complete document. But my lords, our whole contention is that the terms of the tender does not require submission of the joint venture agreement. So that cannot be made a ground for disqualification.
Your
And my
Lordship-
lords, stating the otherwise also, does the law necessitate upon us to form a written joint venture agreement? My
Why
lords,
not?
the answer
Why
to
not?
that is no.
Why not?
Because, my lord, a contract, oral contract is also admissible, my lords.
No.
It is upon the party whether they want to write it or make a oral submission.
Your Lordship, if I may add, the e-tender is open for 24/7. So that means they had time to submit the other documents as well. So how else would the committee verify the identity of the other firms at that stage?
My lord, let me address to the timing about it. 6th.
Just a minute. Yes, what else?
And Your Lordship, I would also like to state a judgment which is regarding the balance of convenience, Your Lordship. At this stage, after the judgment and order was disposed on 29/5/2026, the administrative cycle have rapidly moved. So now, Your Lordship, the first installment of public funds have already been released to respondent number 4.
How much has been released?
Your Lordship, mobilization advances of 4.547 crores have already been disbursed.
4.547
crores.
Oh, 4.547 crores.
Yes, Your Lordship.
Released when?
Your Lordship, this was released on 1/7/2026, and before that, Your Lordship, this decision was already made in the meeting minutes of 18/6/2026, Your Lordship.
What decision? Decision to?
Reward the tender to the respondent number 4, and also to speed up the process of the project, Your Lordship, to be completed before May 2027. Because, Your Lordship, because of the writ petition,
The project is to be completed.
by May 2027, Your Lordship. 6 months have already been.
To be completed by May 2026.
Yes, Your Lordship.
And this project is for what? This for to do what? What is the?
Strengthening and transmission and
No,
transportation.
that's all right. In layman's terms,
Yes, Your Lordship.
you were saying 1/3 of Mizoram or something.
Yes,
the
Your
other day.
Lordship. On that point, Your Lordship, I would like to state that it actually, the existing power transformer, which is supplying electricity to 1/3 of the Aizawl city, is overloaded. So, Your Lordship, this project will actually help us replace that overloaded transformer.
1/3 of the
1/3 of Aizawl city, Your Lordship.
of Aizawl city.
Yes, Your Lordship.
Of
Therefore,
what?
time is of the essence at this stage, Your Lordship.
The transformers, 1/3 of the transformers are
Your Lordship-
overloaded.
Yes, Your Lordship. The power transformer supply electricity to 1/3 of Aizawl city is heavily overloaded at this stage.
So the transformers are overloaded,
yes,
not
Your
the
Lordship.
city.
Yes, Your Lordship. The transformer is overloaded.
So it is 1/3 of the transformers. The transformers are loaded by
The
how
it
transform
supports the overloaded transformer supports 1/3 of Aizawl city.
1/3 of Aizawl city.
Yes, Your Lordship. So now, Your Lordship, the specific project
Just a
will.
minute.
Yes, Your Lordship.
So when was the work order issued?
Your Lordship, it was not issued because of the writ petition. There was a stay.
No, now it has to be issued.
Yes, Your Lordship.
How have you issued, how have you released money without work order?
This, Your Lordship, I will have to ask the concerned.
Let's ask.
Yes, Your Lordship.
It has to be issued.
Yes, Your Lordship.
I'm quite sure the contract agreement has already been signed. Otherwise, how can you release money?
Your Lordship, in the meantime, I would like to submit judgment of the Supreme Court, that is Developer Group India. Se- 2023 7 SCC 814. Your Lordship, in this
2023?
2023 7 SCC 814,
Yes.
in para number 24, Your Lordship, it talks about the fact that once public resources are committed and third-party rights intervene, an entire multi-crore project cannot be stalled to satisfy the speculative financial claims of a single private litigant, Your Lordship.
Yes, because this is it's not we're not very bothered about the profit one is going to make.
Yes, Your Lordship. And, Your Lordship, in another case, which is NG Projects Limited, 2022.
Give us
Your
the
Lordship.
list, madam. We are just reading out.
Your Lordship, I will give the copy if required. I have it.
You don't have a copy for
I
us?
have it, yes, Your Lordship.
And
I
what
have it.
about for your friend also? Our grey cells are limited. We cannot, absorb everything that you say.
Yes, Your Lordship. Your Lordship, in the NG Projects Limited, that is 2022 6 SCC.
Which, just a minute, NG projects, yes, which para?
Your Lordship, that is para number 21.
Yes,
It says that, Your Lordship, if I may read,
yes,
since the construction of road is an infrastructure project and keeping in view of the intent of legislature that infrastructure projects should not be stayed, the High Court would have been well advised to hold its hand to stay the construction of the infrastructure project. Such provisions should be kept in view even by the writ court while exercising its jurisdiction under 226 of the Constitution of India. So, Your Lordship, infrastructure projects should not be clogged by litigation is our emphasis on this regard, Your Lordship. And Your Lordship, in the previous hearing, the Ranok case was already cited by Your Lordship. Ranok case, Your Lordship, that is Ranok International Limited.
oh, Ronak,
Yes, Your Lordship.
Raunak.
Yes, Your Lordship. That has already been cited by your bench, Your Lordship. Your Lordship, the work order was given to them on 28 11
just a
20.
minute, where is this 2023 7 SEC? Okay, developer group.
Your Lordship, if I may.
Just a minute. Madam, there are some more judgments. You are on the judgments with regard to stay.
Because, Your Lordship, initially we were of the assumption that the stay would be dwelt in this
I'm
state.
thinking of whether we're thinking of whether to dismiss the appeal.
Yes, Your Lordship.
Not a question of whether we should issue notice or we should dismiss the appeal.
Your Lordship, if that is the case, then we would like to rely on the submissions that we had made in the petition, all the case laws, Your Lordship. That has already been exhaustively dwelt
Okay.
upon. And, Your Lordship, if I may be allowed to state that the work order was given on 28 11 2025.
11
28 11 2025.
work order
Because
on 11
28 11 2025, Your Lordship.
28 11 2025.
To respondent number 4, because they were the successful bidder.
Okay, work order given on 28.
Yes, Your Lordship. And then it was stalled because of the stay which was granted in December. And then the work only recommenced after the 29/5/2026, Your Lordship.
Because the thing is, either we give a stay, even if we don't give a stay, they are going to go to Supreme Court anyway. So better to dispose of the entire matter. Anything else?
No, Your Lordship, that is my submission.
That is one way
Your
of
Lordship.
looking at it. Now you tell me if you can convince me otherwise.
Let me rely upon one judgment. This judgment talks about rule of law, level playing field, which is related to Article 14, 19(1)(g) and 21, my lords. I would directly like to take you, my lords, to para 36, my lords. Page 21, my lords. Internal page 21.
Yes.
It is about unclear terms of the tender, my lords.
Yes.
How it has to be viewed in terms of articles, my lords.
Yes.
We find merit in this appeal. Standards applied by the court in the judicial review must be justified by constitutional principle which govern the proper exercise of public power in a democracy. Article 14 of Constitution embodies the principle of non-discrimination. However, it is not a free-standing provision. It has to be read in conjunction with a right conferred by the other article, like Article 21 of the Constitution. The said Article 21 refer to the right to life. It include opportunity. In our view, as held in the latest judgment of the Constitutional Bench of 9 judges in I.R. Kolho versus State of Tamil Nadu, Article 21(14) are the heart of the chapter on fundamental right. They cover various aspects of life. Level playing field is an important concept which...
Mr. Counsel, level playing field, you have got a level playing field, that's why you took part in the tender process.
Malas, let me show you why, Malas, why I don't get a level playing field, Malas. Let me take you just one document of the writ appeal, Malas.
He has got no case. What is level playing field he has got? Only thing has been disqualified.
Malas, page 104, Malas.
Correct.
Malas, page 104 of the writ appeal, Malas. Malas, let us preview this document to ensure whether level playing field was incorporated by the authority or not, Malas. 104, Malas.
Mr. Counsel, the issue is not level playing field. Your issue is basically whether the non-submission of the joint venture agreement having all the signatures of the partners could be a ground for disqualifying you. That's all.
So,
That's the
Malas,
issue.
that is,
There's no need of
that is
elaborating.
completely covered Mahamaya Mineral judgment, Malas.
That's all.
The
That is
terms
all.
were never there in the
You cannot
term.
go beyond that. Now there is one supposing there is a case, say, for employment, and the eligibility criteria is that he should be a OBC. Okay, and there is nothing stated in the NIT that a OBC certificate should be submitted. But an OBC certificate is submitted. But it is the certificate, your name is there, but it is not signed by any authority. What, do you mean to say that the authority who looks into the NIT and the bids of the candidates' applications would give a go-by to what you submitted?
Well, it's to my respectful
It's
submission.
like that. You have submitted a joint venture agreement, even though there may not be a clause requiring you to submit the same in so many words. But all the same you have submitted. Now, what is the fault of the respondents, state respondents, in seeing whether the document submitted by you is a valid document or not? You should not have submitted. You submitted a incomplete document.
Malats, first of all,
That
Malats,
is the,
to my
that is the long short of it.
to my respectful submission to that, Malats, I have not been rejected because of the missing joint venture agreement. I have been disqualified on the ground of not meeting the financial criteria.
Correct.
That has been evaluated on the basis of the incomplete joint venture
Correct.
agreement, which was not
Now-
required
now
in the tender.
Because now
Malats.
you have got to relate the two. Now, to prove that you are a joint venture, you had submitted the agreement. And your documents, the three partners' turnover statements, now that cannot be read. That cannot be read in isolation. That has to be read in the context of a joint venture agreement. That is how we look at it. Okay, right. Heard.
Malats, may you please have a look at page number 105
No,
for the
right.
last time, Malats.
Huh?
One request, Malats.
Yes.
Just have a look, page 104 of the writ appeal, Malats. Malats, this is a power of attorney of respondent number 4, Malats. I have also been evaluated on the same premises, Malats. Malats, may look at the second last line left hand side, which is in bold. Technical specification number 2025 power 480_2. My lord, this is a power of attorney submitted by respondent number 4. Whereas the impugned tender is 3. They have not even submitted power of attorney.
Look, the problem is Ronak International and Tata Motors has clearly decided this point, that we cannot go into the weakness or the fault or the charges made in respect of the selected tenderers when you yourself have not passed the threshold, crossed the threshold.
My lord, that is why we are before your lordship, because we are
That is
challenging
what
our
the Supreme Court has
disqualification,
said.
my lords.
If you want, I'll read it for you. What
My lords,
the
my lords,
Supreme
I'm
Court
very,
has said.
my lords, I'm very well aware of. I don't want to disturb your lordship.
There are so many, I think you know very well,
lords,
those judgments.
I also want to say the Supreme Court also says that the judicial intervention is required when there is an undisputed amount of favoritism.
First of all, you have got to show that you have crossed the threshold, that you are selected. A person who is disqualified, now if we keep on allowing, they will have 1,001 reasons.
My lord, on the first perspective,
disqualify.
I respectfully submitted.
The thing.
My lord, may at least admit the appeal and not grant the stay. Let me allow to present my case before the writ appeal,
It's
my
the
lords.
same thing. You will go to thing. You will go and
My lord,
file an appeal.
we really
and-
want our take our chances here, my lords. My
Huh?
lord, may at
No,
least
you
admit.
take your chances in the Supreme Court. You've got a right to go there.
My lords, we have-
Let it be clear.
My lord,
We will-
let
we
me
will-
avail my this right also. My
Huh?
lord, may not grant the stay, but at least admit the appeal. Let our present.
Why?
let-
For
let
what
me-
purpose? When we don't find any ground to allow it.
My lord, my case is wholly covered by Mahamaya Mineral
That
judgment,
is
my lord.
why you can go to the Supreme Court and say that the decision of the High Court is wrong. But we find the decision of the Supreme Court in that case does not cover the facts of this case. Every ratio in a case cannot be treated as a Euclid's theorem. You know that.
Yeah,
It depends on the
yes.
facts and circumstances of each case. A little difference in facts changes the precedential value. Then,
I bow down
where
to
is it?
that, my lords.
Heard so and so, dismissed. We'll pass the order later.
Item number 2.
Please, Your Lordship, this matter was listed day before yesterday, and today it's listed so as to enable the officers
Yes,
of the
yes,
PWD
that
to...
conveyor belts.
Yes.
Yes, please show us.
Now, hey, hello. Sorry, Your Lordship, I didn't tell them that to make 2 copies, so only 1 copy is there. So.
Saving money. What?
Your Lordship, the first page...
Basic courtesy, so you should show. You're the government.
Yes.
You're not a poor litigant.
Sorry, it's my fault, Your Lordship. I didn't tell them that we have to make 2 copies, etc. So the first booklet is for Your Lordship for carousel 1, and the first flag we have made a flag will be a map, will be drawing
Yes.
for 1 carousel, Your Lordship.
You've not given a copy to the...
We have briefly shown him outside.
Brief. This is not done.
Yes, Your Lordship.
This is not done. No. This is not the way to conduct a no. We could understand. You have not given 2 of us. We are okay. We could share.
I didn't even have my own
but then
copy
you-
also.
No, this is not done, madam. You give a copy.
Tender my sincere apologies, Your Lordship.
This is not done. This is completely. You are being you are discourteous to the court and to your
Learned
colleague.
friend.
You provide the thing. When?
Your Lordship, I can explain that if their appearance or presence be...
They need not come. You
Okay.
give it, but
Okay.
they
Tomorrow?
need.
Tomorrow I can do
Sorry,
it.
I
Sorry.
don't understand.
Sorry.
Tomorrow is fine, Lordship. If
Your Lordship, tomorrow.
it's up to your Lordships.
Yeah, or any day.
Let it be next week because tomorrow we have got too many
Or Lordships,
orders
then
to pass.
is it fine if they file it in the way of, by way of affidavit? It'll be better, I think, like that.
You file an affidavit?
Yeah, we can do that also, Your Lordship.
Okay, right.
And we can
Miss,
take it up
Mrs. Mary L. Khyangte, learned GA, submits that. You see, if it's affidavit, again it's a problem. The cost, everything. Now they are only providing 1. Affidavit, they'll have to make 2 plus 1 plus...
No, but then I think Lordship, it'll be better if it's in the record, because once it's like this, sometimes what happens is... when
Anyway, we're ending to the end of... We're coming to the end of this case,
Yes,
basically.
yes.
You clarify that. I mean, right, Ms. Mary L. Khyangte submits that she will submit affidavits in relation to the order dated 28/7/2026 within a week.
Yes, Your Lordship.
What, within a week or within
2 weeks, Your Lordship.
2 weeks? List the matter on, give a date.
18th of August.
Your Lordship, in the last court date, P&E department were impleted
we
as a
fixed the
party,
date.
and 3 weeks was
3 weeks was
given.
given
So
to
Okay, list the give a date after 3 weeks.
The same date, I think, will be good, Lordship.
20 of August.
Certainly.
23. Me.
It's 23.
23 or 20th?
20th, he said 20th.
20th. 20th of August.
Obliged, Lordship.
23 is a Sunday.
Okay.
Oh, we're finished.
Local lang nga ito. May please, Your Lordship. Your Lordship, I would like to seek this Honorable Court indulgence, Your Lordship, in making a mention of item number 3 and item number 11 of today's list, Your Lordship, daily list. Because I have many items in court number 2, so if I may seek for upgradation of the item, Your Lordship.
Okay. Which one? Item?
Item 3 and 11.
Okay.
Oblige, Your Lordship.
Item 3 and 11. Yes, madam, what?
May I seek Your Lordship indulgence in mentioning part 2, item number 16, hearing list. If this matter may be taken up next week, my lord.
Okay, on the prayer for adjournment made. Yes, who's for the other side? Item 16.
Item 16.
On the prayer for adjournment made on behalf of the petitioner,
Petition, appellant.
appellant, list the matter in the next week.
Oblige.
Item 3.
Yes,
May it pleases your lordship. Am I audible, my lord? My lord, with regard to item number 14, my lord.
huh?
My lord, item number 14, my lord. I have instructions. I have instructions to withdraw this case, my lord.
Okay, right. Mr. M. Biswas, Learned Counsel for the appellant, a petitioner, submits that he has got instructions to withdraw the application. Who appears for the other side? Miss Linda
Yes,
L. Ms. Mary L. Kyangte, APP, appears for the state. The prayer of the applicant is allowed. The petition, the application is dismissed as withdrawn.
Item number 3, please.
Item number?
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 13, Lordship. Kindly, Lordship, this matter may take next week, Lordship.
Why? No. Why? Why?
Lordship, Lordship, there is some difficulties,
No,
Lordship,
no
on my part,
difficulty. We will
Lordship.
take up your wait. Yes.
Lordship, because, Lordship, I could not go there, Lordship, due to my my senior is not well, Lordship, that's why. And in Lordship division bench in principal seat, Lordship, there is death reference case, Lordship. That's why, Lordship, there is difficulty, Lordship. Any date, Lordship, Lord.
Oh, who is the senior? You are the senior. You are the one. This is your case.
No, Lordship, in principal seat, Lordship, my senior HRS Chaudhary is not well, Lordship. That's why I could not go there, Lordship, due to his illness, Lordship. And in Lordship, in division bench 1, Lordship, there is a death reference case, Lordship. And
We can do it tomorrow. Let's the matter
day after
tomorrow.
tomorrow.
Huh? Day after
Lordship,
tomorrow. Day after tomorrow, you have to come here because day after tomorrow is a holiday.
Lordship, next week, Lordship, any date, Lordship.
Why?
I will
Why?
actually,
Why not
Lordship,
tomorrow?
Lordship, I will appear through, Lordship, in normal mood, Lordship.
You will appear.
Because I have to, because, Lordship, I have to place some judgments, Lordship.
Regarding what?
Regarding, Lordship, non-compliance of section 36, 47 and 48, Lordship.
But NDPS now has been covered by the latest judgment.
Lordship.
That Balraj, I think, no? What is that case? There is that latest case. What is that case?
Lordship, any date next week, Lordship. I will appear physically, Lordship.
We'll list it tomorrow. You try your luck tomorrow. On the prayer made on behalf of on the prayer made by the counsel for the petitioner. List the matter tomorrow. Item 13.
Lordship, any date, Lordship, after Lordship possible, Lordship.
Why you are having difficulty with this court?
No, Lordship, Lordship. Because I have to place some judgments, Lordship, regarding, Lordship, the sections 48 and 36, Lordship.
You place it tomorrow. What is the difficulty? We'll give you the WhatsApp number. You place it today also. How does it matter? What is the difference between placing it tomorrow and next week? You place it. You send it to us. We'll read it.
Lordship, actually, I wanted to appear through physically, Lordship.
You need to appear physically.
Lordship.
Okay. Right. Mr. I.U. Chaudhary, learned counsel for the petitioner submits that the matter may be adjourned so as to enable him to appear physically in the court. Accordingly, this matter is adjourned only on the condition that the counsel shall appear physically in the court. List the matter on
4th of August.
4th of August.
Lordship, DP of
Not
Lordship.
4th, listed after that, wait. List the matter on 6th of August.
Lordship, DP of Lordship.
No, 6th point law. No, not 6th. List the matter on. When was he arrested?
Lordship, he was arrested on Lordship 9/4/2026, Lordship.
9/4/26.
9/4/2026, Lordship.
No hurry then. List the matter on 11th of August.
Lordship, DP of Lordship.
Yes, madam.
Your Lordship, item number 3, this matter is listed for the second time. Your Lordship, this is pertains to the nurse MNC that they have not submitted their MNC certificate before the MPSC. Basically, this is the case.
Whether the answer scripts have been evaluated?
Yes, my lord.
Evaluated. Then do they come within the...
My lord, I have sealed cover. If lordship allow me to place it on record.
So only those persons who have secured 332 marks can participate in the interview process.
Yes, lordship.
But they were allowed to participate, correct?
They have not.
They have not.
As part the last, they did not have interim order.
Oh, did not have interim.
The
So,
only thing is that, Lordship, the selection process was not stalled.
Acha,
Interview was not stalled, but the result will
was
not be
not to be
published.
made. Oh,
Yes.
was not to be made.
That's the
So,
interim.
so yeah, the question is this: whether
Yes.
you have secured 332 marks.
Yes, yes.
So,
To our anticipation, I will be able to secure the cutoff mark.
yeah, no, doctor. No.
If the answer sheets are properly scrutinized and examined,
I don't know. Your fate is entirely in their hands. So if you secure the 332 marks,
yes,
then we will have to decide the case on merits.
that's what has been anticipated.
But if it is not, then that's the end of the road.
That's true. That's true.
So these are all the petitioners, all of them.
Not all of them. Those who have secured that the cutoff mark as part the last court order.
Okay, so these are the persons who have secured.
Yes.
Now let me see the names. These are the names of the petitioners.
Yes. Yes.
Lal Chanmoy. Lal Chanmoy. So,
38 petitioners are there. Out of 38 petitioners, at least, I'd like to know how many of them have
yes,
secured.
now I'll have to look, you have to
Yes.
compare, no? Okay, I think petitioner number 1 has secured.
My lord, if your lordship may kindly read in silence, if because now everyone they are watching on you live, live stream.
Okay.
Yeah, petitioner must be very confident that she come forward.
At least petitioner number 1 has secured.
Okay, so anyways, some of them.
Yes, because the first name itself, she's qualified. Then we'll do that.
So then.
Well, private parties now today they have come forward. They are going all that 19 private respondents also.
So you all have come. You all are coming for the first time.
Yes, my lord. I filed my.
You have to file a thing. You have to file a affidavit.
Yes, my lord. If I may be allowed.
So what is to be done now? We wait for the affidavit.
Lordship,
We
the
do not.
private respondents have nothing much to do because they have been selected.
Correct.
They're in
They've
the
got
list.
nothing much to
They
do.
have, they have gone through the interview. They are waiting for
The
the
result.
final selection. As to whether the petitioners are, qualified for personal
So
interview
now
or
we have
not.
got to decide the issue.
Yes.
That's all.
Lordship, since the matter has been examined by the MPSC and now placed before a Lordship, I think there's no reason for keeping the matter confidential because it is the right of every petitioner to know.
Correct. It can be, we can tell them to
Yes.
publish. That's not an issue. But there's so many names. So many of them have qualified.
A copy of that may also be furnished to us.
It can be given, I think. Any problem?
I'll have to seek instruction from the
What
client.
is there? It should be in the public domain.
Yep.
They have got to know.
There's no question of playing
But
hide
only
and seek.
problem is no. But otherwise, what we can do is we can decide the main issue.
Yes.
We have to decide the main issue. The main issue is with regard to whether the non-submission of that document.
Private respondent lordship may I kindly would like to submit that how fair it is because they are able to submit the mandatory documents and all. Okay. The manner how they submit it also.
No, what we'll do is results should not be declared. You file your affidavit. We'll fix a particular date for hearing, for admission hearing. And then if you succeed in the thing, then they will be called for interview and thereafter only the results will be declared. Or else if they don't succeed in the main hearing, then the results will be declared.
It's fine, lordship.
Okay. All right. Mr. J.C. Lanusanga, Learned Counsel for the MPSC, has submitted a list of the candidates who have secured the cutoff mark of 332. A bare perusal of the same shows that some of the petitioners herein have secured the cutoff marks. In view of the above, the only thing that is required to be decided is with regard to whether the reason for not calling the petitioners for interview was sustainable in law. In that way, the matter, the matter for admission hearing on.
My lord, we have not filed counter and even
No, in the meantime you file. How much time do you all need for
Yes.
filing? How much time do you all need?
3 weeks.
3 weeks. Small issue.
Because my lord, one pending matter, similar pending matter is also
the
there.
matter. Give a date. This is the matter on.
25th of August.
Mr. J.C. Lanusanga, learned counsel for the MPSC, comma, Mr. Lama Marate appearing for the private respondents.
15 private respondents amongst 90.
It's okay. Yeah, for the 15 for the private respondents. And Miss Mary, are you filing anything? No.
Your Lordship, I will seek time.
And Miss Mary L. Kyangte, learned GA, are granted and may file their affidavits within the set before the next date.
Much obliged, lordship.
Item
The
number 11.
interim order to continue till the next date.
Item 11.
Yes.
My lord, this is bail application.
The difficult case.
Yes, my lord. But if it's not that difficult. We have good.
It's not that
grounds.
difficult.
Yes, my lord.
Okay.
My lord, the petitioner was arrested. If I may take your lordship to page number 2 of my application.
Page number 2. Yes.
My lord, if I may read, the applicant was arrested by the police personnel on 18 May 2023 at 3:30 p.m. for involvement in connection with seizure of 414 grams of suspected heroin from the joint possession of the instant applicant and another co-accused, and was booked under 21C/29 of the Indian PS Act. That, my lord, bail was granted by the coordinate bench of this court on July 2025. My lord, at page 77.
Page?
Page 77 of the application.
Yes.
Date of order dated 21/7/2025.
Yes, yes.
That, my lord, thereafter, the applicant was again arrested in another case.
While on bail.
Yes, while on bail, your lordship. Because
What else
he,
is, why is it not difficult then?
see,
Under 22C.
yes, my lord. And since he's already got a case before this case, and then he became a suspect, and then he was framed in a way in the second case.
When were you arrested in the second case?
On January 6th, 2026. 6th January 2026.
For what? Methamphetamines?
Yes, my lord.
How many?
My lord, 30,000.
30,000 tablets.
30,000. Yes, my lord.
30,000 tablets in seized from where?
Seized from one. He was supposed to collect one parcel. So another person said that we will keep this in your parcel, and another person will collect it from you, from your house. So, and then it was the source, the prosecution's source. The, my lord, trial is conducted. He is still not convicted. So, my lord.
This is a January 2026. Yes.
Also, my lord, the other
Very difficult, madam. How do we do the 30,000 tablets in
my
your
lord,
house? They're also in your parcel. if you can, I thought you'd have a better story, but that is.
The my lord, trial is going on, so if I may submit one citation regarding that.
What is the latest judgment, with latest order in bail, Ms. Mary?
Yes, Your
And
Lordship.
that where it says that the twin conditions provided in section 37 will have to be met for bail involving commercial quantities. It came last week only.
I
Justice
haven't.
Sandeep Mehta.
I haven't gone. I haven't have the information of that, Your Lordship.
My lord, if I may submit just one citation.
Yes. Yes.
My lord, if I may take your lordship to the operative portion directly, at page 5 at para 7. At this stage, the learned ASG appearing for the petitioner submitted the power of the court was constrained by section 37 of the NDA-NPS Act, which is applicable even at the stage of an appeal. He relies on a decision of this court in the case of so-and-so. There is no dispute about the fact that the appellate court is bound by the constraints of section 37 of the NDA-NPS Act while considering the prayer for the grant of bail during the pendency of an appeal. However, if in the facts of the cases an accused has undergone a substantial part of the substantive sentence and considering the pendency of criminal appeals, his appeal is not likely to be heard before the accused undergoes the entire sentence. The appellate court can exercise the power of releasing the accused on bail pending the appeal. That, my lord, the trial in this particular case has been going on for a very long
Now
time.
you see, okay, this is the judgment past very long time.
Yes, my lord.
Then when did it start? When was charge sheet filed?
Charge sheet was filed on. Charge sheet was received by the trial judge on
Special
3rd.
leave petition criminal 896 of 2026.
B. Ramu. B.
I think that is State of Punjab versus Balraj Singh. State of Punjab versus Balraj Singh, special SLP criminal number 896 of 2026.
My lord, if I may continue.
Huh? Yes. No,
Charge-
so this case you're talking about
Yes, my lord.
says that if in the facts of the case an accused has undergone a substantial part of the substantive sentence, now under 22C, what is the minimum sentence?
10.
10.
Yes, my lord.
How many years has now substantial sentence, part of the sentence would be how much?
4.
4 years.
Yes.
4 years.
3, 4 years, my lord.
But then in this case, he has been arrested only in January.
No, my lord, he was, in this case, that was the new case.
Yes.
My lord, in this first case, this is the first case.
No. First case he has been arrested because he was caught while on bail in another case. So you
No, my lord,
are asking for bail in the earlier case.
Yes, my lord.
Oh, you are asking for bail in the earlier case.
Yes, my lord.
But then his ground, the reason of his bail.
The reason was
because
basically violation.
You have to first get bail in the second case. Otherwise, there's no point.
Yes, my lord. Bail, second bail also rejected.
difficult, madam.
My lord, even basically, even in this case, if we were allowed bail, we won't be able to execute a bail bond because.
Very difficult, madam. Very
My lord,
difficult.
here, this is the first case.
This is the first case.
Yes, my lord.
Where have you said that?
The first case was the police case. He was arrested in the year 2023.
You see, you have not, in your prayer also, we don't know which case you are asking for bail. How do we know in which case you are asking for bail?
My lord, is a special narcotic case, PS, arising out of SR number 334 of 2023.
Okay. So, in SR number 334, you are asking for bail in the other one.
We had already asked.
Asked and you had gotten bail.
We have not gotten bail. Bail got
You
rejected.
you had been given bail, but then you were arrested because you were caught in another case, in the
No.
second case.
In this case, we were granted bail.
Yes.
This is the first case. So while we were on bail in the year last year, then the new case, which
Okay.
is the excise case,
So, because of that new case, your bail was cancelled.
cancelled. And this is and we applied for bail in the district
I
court.
think in that case, you will have to go before the same court.
We did, my lord. We applied for
no,
bail.
but then that is the thing, that is the requirement. The High Court notification says that once bail is given or rejected by a particular judge, all subsequent applications have to go before that particular judge.
Yes, that is why, my lord, it was laid before the Chief Justice.
Okay.
And then, however, I asked, like, why are they listing to another bench as per the roster? And the registry told me that it's as per the direction we have
But where is
received.
that?
It must be in the note sheet.
Okay, as per the regular roster.
Yes, madam. That is why it got listed in the senior bench. That, my lord, previously
This
also.
judgment not by Justice Sandeep Mehta, this is by Justice Sanjay Karol.
This. Yes. Then, my lord, in this case, in the previous bail application before the coordinate bench, we were granted bail on the basis of Article 22 and long incarceration, because the witnesses have been caught for like.
But you see,
so many times.
those bails are subject to conditions that you won't do an act of similar nature, that you will not abscond, that you will attend the
Yes,
court.
we attend
But then
the court regularly.
But then you did that second case.
Yeah, my lord, we didn't do it. We were framed, and the trial will show that we are innocent.
But then section 39,
37.
37, no, not 37, that, come on, in the PSAC, culpable mental state, that is
36. I think.
36, culpable mental state. So, you have got to prove your innocence
30.
during trial.
Yes, my lord. We attended the court regularly. However, my lord, the witnesses have been called more than 20 times. And since last year also, nobody has turned up.
35.
Even till now, we had asked before the trial court for.
What is the stage of trial? The case?
It's prosecution evidence, Your Lordship. Prosecution evidence. In fact,
Prosecution evidence.
yes.
Yes, but then how many witnesses have been examined?
2, my lord.
2 out of?
Out of 6.
Your
When,
Lordship,
when did the trial start?
The charge sheet was received on 13/9/2023. And he is incarcerated for minus, while he was on bail, till as of today, he is incarcerated for 2 years, 9 months and 24 days.
Oh, that's okay. But when was the last witness examined?
Your Lordship, the problem is that in the last court date, case diary was called for, even though this is charge sheeted, it was wrongly called for. And
Case diary is different from
yes,
case
yes.
report.
Once it is charge sheeted, then case diary do not have much relevance. So a scanned copy of in a charge sheeted case in bail application, a scanned copy of the trial court record has to be called for, but it was not called for, so we cannot ascertain. But as per the annexures that my learned friend have annexed, the last examination was conducted on August 2024, but that for sure I cannot say because the record
Yes,
is
it
not
is
with
true.
us.
My lord, here are the production dates, and PW2 has been called 23 times, and in between false production.
PW
2
has been called
23 times.
23 times.
PW3 called 20 times. PW6 called 6 times, and nobody turned up till day before yesterday was the last call.
Why isn't the court issuing warrant of arrest against those witnesses?
Your Lordship, I was going to pray for the calling of the TCR, scan record of the TCR. We can have this matter again on Monday.
My lord, if it can, I will be out of town next week.
When do you
If
want?
it can be taken up tomorrow, because the
They will-
case
they-
record is just next.
They will have to
They-
scan
They
and
need
transmit.
orders
it.
have to go. We'll do it next week. Next week. What date? Choose a date.
My lord, Monday.
Monday. Okay. They'll have some time to bring the TCR then. Right. List this matter on Monday. In the meantime, registry shall call for the TCR of the scanned copy of the TCR. Yes, hello.
Item number 1.
My lord, is it item number 1, my lord?
Yes.
My lord.
Yes.
My lord, yes, my lord. I am appearing on behalf of the petitioner. My lord, there are certain glaring infirmities in this judgment and order, my lord. My lord, see the
No,
matter pertain to
Mr. Counsel, this is
Madam.
you are challenging an order of a civil court, right?
my lord.
Now, if you are challenging an order of a civil court,
My lord.
then why do you come under 227? It's very
Madam.
it
Straight-
limits
Madam, yes,
limits
madam.
because your only challenge can be on the grounds of jurisdiction.
My lord, absolutely.
So
absolutely. Quite right.
where is the wrong?
My lord, yes. My lord, kindly see the basic claim in the suit is, my lord, compensation for the damage of the vehicle and mental agony. Now, Lord, see, in such a situation, Section 166 of MBI Act 1988 is very much clear. Now, the appropriate forum is, my lord, MACT court, my lord, in terms of the Section 166.
No. This is asking for civil suit. You can
No,
file
my lord, no, Lord,
Mr.
Lord,
Counsel, if that is your case, you file a civil suit.
No, my
You
lord,
file an
no,
appeal. Sorry, you file an appeal against this order. Not a. It can pass an order. There is nothing wrong. This is not a.
My lord, kindly, Lordship, just give me little ground, my lord, little time. That why I have 227, my lord. Lordship, quite, I am only satisfying on this point, my lord, straight away. Lordship, kindly take it on page 50. I will not go to the mate of the case, straight away on law point, my lord.
Yeah.
My lord, page 50, issue number 2, whether the suit is barred by law.
Page 15.
50. Yeah, no, 50, my lord.
50.
Issue number 2, whether the suit is barred by law. Issue number 2.
Yes.
Now, Lordship, just take turn to next page, page 51.
Yes.
The line start from found which violate the proceeding of the suit, and therefore, issue number 1 is decided in positive,
Yes.
and the issue number 2 is in negative.
Correct.
Decided.
So it says that the suit is not barred by law. When it says
No,
that the
no,
suit,
negative.
whether the suit is barred by law, when the answer is negative, it means that the
My
suit is not barred by law. So
My lord.
there is no conflict between the finding in respect of issue number 1 and 2.
My lord,
There is no
issue number
conflict.
one-
You are in conflict
My lord,
with the observation, with the findings of the court. The finding of the court is in perfect consonance with each other, with the
Ma'am.
two issues.
My lord. Now, Lordship may just take a turn to page my lord, 59, my lord.
Yes,
59.
yes,
59, my lord.
yes. I have got 59. Tell me.
My lord, yeah, page 59, Lordship, kindly see that how the determination was, my lord, arrived at.
Mr.
Therefore-
Counsel, this is not an issue of jurisdiction. This is an issue of the court not applying its mind or not having a discussion or a finding. So you challenge that in an appeal, not in a 227.
Lordship, perversity, my lord, if apparent on the face of the record, my lord, kindly see the suit is what for? Lordship, kindly see the suit for. It is not a case which is, my lord, covered by the insurance event. Anyway, my lord, kindly see the suit part, my lord. Page 15, my lord. Plaint,
Yes,
15.
page 50. Yes,
15, my lord. 15, 15, my lord. Plaint.
plaint 15.
Yes. Sorry, my lord. Plaint, my lord. 15.
Yes,
The claim is basically, my lord, mental agony and price of the vehicle. These are two components. Now, Lordship, kindly see 166, my lord, MBI Act. My lord, if there is a jurisdictional error, the power cannot be exercised by under the law. The court cannot decide, my lord. My lord, the judgment itself is, my lord, suffering from perversity. My lord, section 166 for a moment, my lord, only, MBI. (166), my lord.
just a minute. Just a minute.
My lord.
Page 166. In the section 166, you mean?
Yes, my lord.
MV Act 1988. Yes.
My lord, this is the special legislation says 166 application for compensation. An application for compensation arising out of an accident to the nature specified in subsection 1 of section 165 may be made by the person who has sustained the injury by owner of the property or whether death has resulted from the accident by all or any of the legal representative of the deceased person. Here two claims, my lord, he has made. First is that my lord, the
okay,
person-
Mr. Counsel, first of all, who has sustained the injury in this case?
my lord, that owner.
Owner. Now, has he claimed money for injury?
Yes, my lord, mental agony.
Mental agony is not mental.
My lord, kindly see,
And
my lord.
another thing, Mr. Counsel, where is your averment in your plaint? In your where is your written statement? Let us see a written statement.
My written statement, I have taken another ground that the vehicle was not insured, my lord. My written statement. I have specifically pleaded and it was not answered. Written statement, my lord. Lordship may kindly see my written statement.
No. It is not your case that this case should be decided. This is a case where a landslide has damaged what vehicle is that? JCB?
Medium-sized truck. It's
Medium-sized
yes,
truck.
Isuzu.
If the landslide has damaged it, where is the question of MV Act?
My lord, kindly see.
No
my
case,
lord,
Mr.
once
Counsel.
NBI
Either you withdraw or I am dismissing your case. Simple.
then Lordship may kindly give us a liberty to approach before the appropriate.
Yes, you go there.
My lord, only prayer, my lord, section 14 is there, my lord, limitation. Actually. One observation.
That you apply, then you tell them condonation section 14.
Small observation. Small observation.
Mr. Counsel, you do that. Why should we go into that issue? Heard Mr. S. Chamare, learned counsel for the petitioner. Also heard Mr.
Seetlan Lima, Legal Aid Counsel for
Legal Aid
sole
Counsel
respondent.
for the respondent number 2. Then you take this last order, para 2, 3, 4, 5, 6, 7. The petitioner's counsel, the petitioner's counsel at this stage prays that he may be allowed to withdraw the petition with liberty to approach the appropriate forum. Appropriate forum with an appropriate petition.
Well,
The
well,
may be allowed to file an appeal. You want to say that?
yes, yes.
Okay. May be allowed to withdraw the present petition with liberty to file an appeal against the impugned judgment and order.
Well,
The prayer of the appellant is allowed. The petition is accordingly dismissed as withdrawn, with liberty as prayed for.
My Lord, if the interim order may be vacated.
Interim order stands vacated.
Oblige.
Item number 2.
My Lord, in this case, may I seek a week's time to submit a
First, one question to you. Any advertisements were issued?
Pardon?
You were given work orders, correct?
Yes, my Lord.
Was it on the basis of any NIT, any notice inviting tender?
No, my Lord.
No. Then okay, another question. Has the work started?
Yes.
Work has started.
Yes.
How much?
They were preparing for.
How much
collecting
percentage
the
completed?
You
don't know?
I don't know in terms of percentage, but,
But
materials were collected.
Materials were collected?
Yes, and some works were started.
Work was started?
Yes.
You please find out that. But one thing, how can, you see, this is favoritism. You cannot be given a work order without a notice, without a NIT. This is not a restricted tender or anything. Even for urgent matters, restricted tenders are there. Anyway, will you file your affidavit?
Lordship, the reason is that we are also in a hurry in disposal of this case. We tried to file affidavit, but in the meantime, the other 7 petitions came up at the time when we are trying to
Mr. Counsel,
find.
the issue is the same.
Same, exactly same, Lordship.
The issue is all the same. It's only the issue of whether the cancellation of the work orders is sustainable. That's all.
Lordship.
One thing is very clear, that there was no NIT issued. And there are decisions of the Supreme Court regarding granting of work orders without issuing NITs. Okay?
Lordship.
Look at you have to burn some midnight oil. Number 2 aspect is whether they have started work.
Lordship.
And they have started work, and to what extent? So you have to clear that. If they have not started work, you have got to say they have not started. If they have started work, you have got to at least inform this court how much work they have done.
Lordship.
Okay, right. Mr.
Tilan Siyama.
Siyama, learned counsel for the AMC.
Lordship.
Is granted
1 week's time, Lordship.
a week's time to file his affidavit in opposition, wherein he will clarify as to whether any notice inviting tender had been issued in relation to the work order that has been given to the petitioner. He shall also clarify the percentage of work done by the petitioner. This is the matter on
13 of August.
Much obliged, Lordship.
Lordship, if the interim order passed early, maybe.
interim order passed. What is the interim order?
It's
Lordship,
interim
that is-
protection granted
Huh?
to, not to allow a lot works for which the works has already been issued in
Yes,
the petition.
yes. Interim order to continue till the next date. So this will be same in 4, 5, 6, 7, 8, 9, 10.
Yes,
Same order. 4 to 10.
Much obliged, Your Lordship.
Obliged.
Item number 12.
Your Lordship, I just received instruction for filing objection, my Lord. If I may be granted time, my Lord. I'll file it tomorrow, my Lord.
What is the ground for grant of bail?
As Your Lordship, there are a number of grounds, procedural, mainly procedural lapse.
Basically procedural.
Yeah.
When were you arrested?
On 3rd February 2026.
So charge sheet has not been filed?
Charge sheet has been filed.
Filed. On?
Your Lordship, I don't have that information, sir, Your Lordship. The main counsel is not appearing today.
Why is he not appearing? We will dispose of the matter then.
No, Your Lordship, since we have not received the written objection.
Not required. You have got to stand on your own legs. You cannot fight your case on the weakness of others.
If Your Lordship permits, if we grants us time.
So, what is the stage of trial? Any idea?
No, Your Lordship. No, Your Lordship. I have no idea.
What is the stage of trial?
Prosecution evidence have, if I'm not mistaken, been taken now, my Lord. And I think 2 or 3 witnesses have been examined as of now.
Oh, prosecution witnesses have been examined.
As far as information is concerned.
What is the seizure?
993 grams of
heroin.
Methamphetamine. Yeah.
Methamphetamine.
Methamphetamine.
Methamphetamine tablets.
Yes, Your Lordship.
So those will be tablets.
Yes, Your
How many
Lordship.
tablets?
Your Lordship, I don't have that much information.
Yeah, okay, right. Mr. C. Zoram Chana, Learned Senior Counsel appearing for the respondent, submits that he will be filing written objection tomorrow.
Tomorrow, my Lord.
By tomorrow. List the matter in the next week.
Your Lordship, if it may be fixed on 4th August, if Your Lordship permits.
List the matter on 4th August.
Obliged.
Item 15 and 16.
May I please, Lord? And I apologize to appear through VCM, Lord.
No problem.
Lord, this is connected with 17, 18, 19, 20 and 21 also.
Yes.
May I please, my Lord?
Yes, yes.
Yes, my Lord. My Lord, item 15 and 16 were listed, my Lord, day before yesterday. My Lord, and item 18 and 20 are the 2 other appeals of 2 of the managers, my Lord. One of the manager has also been released, my Lord, which is Kajal Kanti.
What? 18, 19 are managers?
Are managers, my Lord.
18, 19 are managers.
Yes, my Lord. If I can just show, my Lord, the impugn order itself, where the prosecution called them as managers, and the finding, my Lord, to that aspect, my Lord. Just 1 second, my Lord. If my Lord may just have the impugn order, my Lord. My Lord may use item 15 as a parent, my Lord, appeal. We will argue all from there only, because page numbers in all the appeals are same.
You mean from the thick file?
Yes,
from the bunch.
Yes, my Lord. Of Ravi Gujalia, item number 15. My Lord, we can argue all from them, my Lord. If my Lord may just have the impugn order.
Page?
My lord, the impugn order, my lord, can I just refer to internal page, my lord, of the impugn order, which is at the bottom, at page number 183, para 309.
It will be at the top.
Which page?
Page 183, para 309 of the impugn order. My lord has it.
Yes.
My lord, may just say para 309 A4 Vimal Kishore, manager of MCP.
Okay.
My lord, I want to show one interesting fact in the impugn order itself, my lord. My lord, may just see the page 192 at para 338. My lord, the only ground for conviction of this person is that he met two fuel pump people from whom he purchased high speed diesel. Para 338, my lord, may just see this finding. This court further find
Yes.
A4 directly entrusted with procurement of high speed diesel from the concerned filling station on behalf of MCP. The evidence of PW 38 and 39 clearly established several cash memos and voucher allegedly issued by the concerned filling station and utilized by MCP for claim of CCIS. This is the transportation subsidy. Were not genuine. So the allegation is that he met PW 38 and 39, purchased diesel, and several cash memos of those 38 and 39 were found not genuine. That is the allegation. My lord, may just bear with me and come to para number 321 and 22 at page 187. My lord, the court, instead of recording the cross-examination, records the examination in chief and passes the conviction order. My lord, may see page 187, internal, para 32 and 321 and 322. It in italics, my lord, in regard to PW 38, Huawa filling station. This portion is recorded. I know Vimal Kishore, he is our customer. He used to purchase diesel 3-4 times a month. He never purchased more than 150 liters. On 2nd of March, ACB came to our workplace to show me the cash memo, which was allegedly our and issued in favor of MCB, but it was never our cash memo. This kind of cash memos were never used by our filling station. My lord, this is examination in chief. My lord, may just come to page 591. I have placed on record the complete cross-examination. Page 591, my lord, in the other volume, not in this, in the volume 2.
Book 591. The documents filed with your appeal.
My lord, other thick volume, my lord, the other volume, volume 1. My lord, these cash memos were never sent to FSL, never even, my lord, if a person says this is not my cash memo, there is something else my cash memo, the IO should have taken what is their original cash memo to compare.
Page
Let me see what happens. 591. My lord, the
Yes.
yes, my lord. My lord, may just see 591, serial number 2. My lord, this is the chief which is recorded in the order. But what the court did not consider is the cross-examination at page 592. My lord, may I have the chief at page 5, cross as 592? It is a fact that POL receipt showed to me by the police during investigation was not our receipt. It is also a fact that for comparison with our original receipt from the receipt allegedly issued by us and showed to me, our original receipt was not seized by police. So what is the comparison? Today, investigating agency, page 592. The code only records the chief, my lord, at page 591. I am reading the cross-examination. And these bills were scrutinized by the government servant. While acquitting them, the court says they did their duty perfectly fine, there was no error. My lord, may I have 592, my lord, I was showing, my lord, just 2 questions in that. Serial number 2. It is a fact that POL receipt showed to me by the police during investigation was not our receipt form. It is also a fact that for comparison with our original receipt form, the alleged receipt allegedly issued by us and showed to me, our original receipt was not seized by the police. So there is no original from comparison. Then my lord may just see 4, which is more important. It is a fact that the receipt showed to me by the police, which I stated in my examination of chief, is not exhibited in the court. So even that, when the witness was asked, where is that 4th? He said it's not exhibited in the court. 5 is more important. It is a fact A4 colleagues purchased diesel. We used to issue cash receipt. So my lord, then the investigating officer and this witness himself saying that we issued cash receipt to MCP, but this is not mine. Original has to be, the comparison document has to be recovered. It is not done. He says even this one is also not exhibited. My lord may just see, to acquit the government servant, my lord, the finding is contrary. My lord may just one paragraph of the impugn order. Internal page 302. So to convict this person, this was the finding. To acquit the government servant, my lord may have page 302, para 588. He says these bills are genuine.
Para 508. 588.
No, 588 at page
That will be in
302.
the impugned order at page 302, where the same set of facts have been leading to an acquittal. Internal page 302, para 588.
Yes.
Yes, my lord. This is for the government servant, my lord. Likewise, with regard to the alleged purchase high-speed diesel, as already discussed in issue number 2, there is no conclusive proof as to whether MCP actually procured HSD from 3 concerned filling station or not. The evidence on record present mixed and inconclusive picture. One of the filling station, namely so-and-so, admit that MCP used to purchase HSD from their outlet. Similarly, manager of Huawei filling station stated that one manager of Mesocarbon used to frequently purchase HSD from their station. However, the cash...
No, so, but what is the relation of this buying this diesel or whatever?
There was a time period.
Huh?
There was a time period. The electricity connection came after 1 year from the date of start of production. So the prosecution made out a case that since there was no electricity connection, your factory could have not been operational. IU gave a statement in the cross-examination that there is no need for an electricity connection. They had a genset over there, and for production of this quantity, not required to have a electricity connection. This is a positive finding by the IU. The cross-examination categorically stated that there was a GD genset for which, because these bills of diesels were placed, so there was a DG genset there, the production was happening. IU gave a statement to that effect in a cross-examination. IU is my star witness. IU establishes everything. So my lord contention is there cannot be a different test to acquit, a different test to convict based on same facts. All these people, my lord, the government servant has checked each of them. My lord, just one more page, my lord, may see the stellar quality of document which was seen by the people, my lord. Just page 96 of the appeal. One, my lord, one more thing I want to show. These are sample document to show production.
The first document of the appeal bundle, I believe my lords already has that open. Where my lords was looking at page 591, that same bundle, page 96.
Annexure 1.
Annexure 1.
So, my lord, when the goods were imported from outside Mizoram from Meghalaya,
Yes.
my lord may see what documents were there. There are 60,000 documents of this nature. Page 96. I have just produced some sample document.
It's likely to be the first page.
Page 96.
Yes, my lord. Annexure 1. My lord, this is after the appeal, my lord. Just right
Page
after.
96, yes.
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 Okay, yeah.
My lord may see, when we imported the goods, my lord, what I paid Mizoram value added tax. My lord, it records, my lord may have serial number E, mode of transportation, which is the truck number, the quantity, then my lord, from which place it is coming to which destination it is coming, who is the seller. Neither they have done any investigation to the seller, that nor any statement of any truck driver, nothing was taken. Then my lord may just see the next page, road challan. It has stamp of these government official, my lord, who has physically verified it. Page 97. My lord may see at the bottom it says Inspector of Taxes, Check Gate, Verengte. Multiple government officers done stamp. These are all people who have authenticated my documents, my lord.
Where is the authentication? Where is the exhibit?
My lord may have 97, my lord, page 97.
This is exhibited.
These are exhibited documents. My lord, page 97 at the bottom, my lord, it is road challan, which is verified and checked by the inspector, tax gate, Verengte, my lord.
This page 97 is exhibited as what?
My lord, these are document along with the claim, my lord, which was submitted by the MCP. These are exhibited documents, my lord.
By the prosecution.
And my lord, may I see?
By the prosecution.
By the prosecution. These are not my defense documents. My lord, and they have come that these seals are genuine. They have verified. They have done nothing. These documents are original. And my lord, not only this, these documents are periodically uploaded into the government website to claim these benefits, my lord. And these government servants have only uploaded, my lord, these website on the document after doing a physical verification of these documents. My lord may have page 98, my royalty documents. I paid royalty on it, my lord. And 98. Government of Meghalaya, my lord, royalty I paid. Then, my lord, 99. Again, my lord.
Yes, anything else? Anything else besides that?
My lord, only to this limited aspect. My lord, only a limited aspect, my lord. Again, my lord, today we are at the stage of suspension of sentence, my lord. These are all I have arguable case, my lord, to show. I am under imprisonment of 3 years with a common, my lord.
3 years or 2 years?
2 years, under 3 years.
Under 3, imprisonment
Under
of
3,
2 years
two.
plus.
My lord, section 389(1), my lord, gives my lords the power to suspend it, my lord. It is not contingent on 389(3). My lord, the application is under the new BNSS.
This is under what?
My lord, the
Under
new
430?
431, my lord, the last order records 432. It should be under 1.
Yes.
430 subclause 1 of the BNSS, my lord. And my lord, I have shown last time, my lord, a compilation of at least 60-70 orders, my lord, of different high court, and this high court under same section, my lord, is suspensions are granted. My lord, to deny, my learned friend last time read an order of the trial court. The trial court order, my lord, one is a limited duration order till the time I file an appeal. Even in the trial court order, my lord, there is no special reason recorded, because 389(3) says you have to record a special reason, not a reason, but a special reason. I have never jumped bail. I have not skipped a date. There is no NBW against me. The court says I may not be able to come to the court. That is the only reason given. In my suspension, my lord may see, this is a common order to all. My lord can just see the...
That would be page 40 of the suspension, which is filed separately.
Yes, my lord. So my own managers, my lord, acquitted. The purchaser are acquitted. The government servants are acquitted. So page 41, if my lord may see, the only reason which is given,
Yes.
In the suspension.
only reason is that I may abscond and it is difficult.
That can be secured.
My lord,
Page-
since today is fixed for this suspension of sentence, my lord.
Yes, yes.
On merits, my lord, we have many things to say. We have examined 117 witnesses. And the learned counsel, instead of focusing on who is acquitted, my lord, I think they should come to their own case. Each case, each person has their own charge. And in suspension, my lord, the learned trial court has given a reason. It's a misappropriation of a huge amount of 3 crores, more than 3 crores, which affects the public exchequer. And moreover, my lord, there is a chance of the appellant absconding. During the trial, my lord, he was not convicted, but now he is under conviction. There is a chance of him absconding. That is the reason given in the suspension.
You see, if it was, the thing is that he's been sentenced on below 3 years.
Yes, madam. Below 3 years, yes, madam. Special reasons have to be recorded. And the learned trial court has already dealt with that, my lord. He has recorded the reasons for not granting the suspension. Otherwise, it's there in
No,
BNSS.
yes. I don't know, we can impose heavy cost upon them. We can impose the bond may be slightly on the higher side.
Yes.
They have got a few lakhs can be deposited.
As my lord deems fit.
Because it's under 3 years.
That's true.
If it was above 3 years, we could have thought otherwise. And plus, there are certain aspects which needs to be clarified.
Considering that this is a very high profile case, my lord, and I think a huge bail amount and that can be imposed upon the appellant.
So there is a misappropriation of approximately 3 crores.
More than 3 crores.
More than 3 crores. Then why sentence only up to 2 years only? Should have given a higher sentence.
That is not even the difference.
My lord, just to only, my lord, add one thing, my lord. The IO statement is, my lord, that there is no loss to the exchequer because on this transportation, production and further transportation, I paid 4.5 crore rupees of taxation.
Anyway, those aspects we'll look into it. Right now we are more on the issue of whether they are going to abscond or not. Doesn't appear. I don't think they'll abscond. They are
6 years, my lord.
they are permanent residents of Gauhati.
Yes.
All of them.
Yes, my lord.
And I think they so I think we can give bail bond of how much? How much do you say?
I leave to the discretion of the court, my lord, whatever is reasonable, my lord. I have not missed out a single date, my lord. There is no NBW, there is no warrant against any of us, my lord. Can see that on the date of the conviction also, my lord, I appeared. It's not like that we were not in the court. We faced, my lord. Why will we run away?
So this is an application under section 430 bracket 1.
Yes,
subsection 1 or subsection 2?
1, my lord.
430 subsection 1.
Where is the last order?
My lord, the last order is dated day before yesterday, my lord. 28th of July, my lord. By inadvertence, my lord, it has come 4:32.
You take the last order, huh? Para 1, 2, 3, 4, 5. Then you take Mrs. Linda L. Fumbo. The learned PP submits that the learned trial court had considered the interim bail preferred by the applicants and suspension of their sentence under section 389 bracket 3 CRPC and had rejected the same by giving by stating that where is that order again?
Lord, page 40 with the suspension, 41. Start from 40.
There would be a separate application for suspension.
Second last page.
Huh?
Page 40.
Lord, second last page is Lord, last page 40. 40 at page 42, 41.
Yes.
Last paragraph.
There will be a separate, I don't believe that would be the file.
Okay.
Because this total suspension runs into only 42
42
pages in total.
42 pages.
It has an index.
Just say the IA number.
The IA number is, my lord, 43 of 26.
Let me see this IA, there will be same thing.
180.
42. You said 42, no?
Yes, ma'am. It starts at page 40.
The relevant is at page 41, last paragraph. Though, my lord, 39.3 is only for a limited period till the time I file appeal. So my lord will still have to consider it to, it's an independent thing, my lord. 381, 1 is independent to 389.3.
No, where is the rejection?
But at page 40 of my suspension application.
Suspension application. Okay.
Yes, ma'am. At page 40 is the order. 41, bottom last paragraph is the important.
Como BNSS coming up, hello. What have I said? By stating that the applicants were not resident of the state of Mizoram and there was a chance of absconding. Further, the misappropriated amount of money was more than 3 crores approximately. Full stop. She thus submits that when special reasons have been given by the learned trial court for rejecting the application for suspension of sentence, the same should not be interfered with by this court. I have heard the learned counsels for the parties. On considering the fact that, on considering the and no, don't say that. On considering the fact that the applicants were on bail during trial and had not absconded during trial, there is every likelihood that they would not abscond during the pendency of this appeal. Further, it appears that the applicants are all permanent residents of Gauhati, correct? Gauhati.
Well, it's 3 of them are Gauhati, 1 of them is based in Kolkata.
Gauhati
And Kolkata.
and Gauhati and Kolkata,
No, it may be more accurate to say Assam and West Bengal.
Assam and West Bengal.
Yes.
Assam and West Bengal, full stop. The acquittal of certain accused persons in the present case and the conviction of the appellants. No, while the appellants, the acquittal of certain accused persons and the acquittal of the present applicants needs to be further gone into on considering the submissions made by the learned counsel for the applicants. Full stop. As the applicants have been sentenced to imprisonment for a period of less than 3 years, this court is of the view that the applicants should be granted bail at this stage. Accordingly, the applicants are granted bail on a bail bond of rupees
2 lakhs for
2
each.
lakhs each, with 1 surety each of like amount to the satisfaction of the learned trial court. The bail granted to the applicants will be subject to the condition that they will appear regularly as and when called for by the court
Please, my lord.
They shall also not leave the territory of India without taking the prior permission of the court. Any default on the part of the applicants will entail automatic cancellation of the bail. Consequently, the impugned sentence to be undergone by the applicants pursuant to the impugned judgment and order dated 23/7/26 passed by the Learned Special Court PC Act Mizoram Aizawl in SR bracket PCA bracket close number 4 of 2019 shall remain suspended till further orders. The IAs are accordingly disposed of.
Can I just make one request, my lord? My lord, if I can get a copy of the order certified, my lord, because I will not be able to release them.
You please ask, you follow the normal route. Yes.
Please. Only I visited the jail, my lord, 2 days back. My lord, there are people who are in jail because the orders are not there, my lord, from last 3-4 days, my lord. That was the only reason.
You please, those things, so we cannot interfere in all that.
But can I just, apart from this case, as just an officer of the court, can I just hand over one judgment, my lord, just for my lord's consideration, not on this case, my lord, just only on this aspect, because I went and I saw this, my lord. There's a guideline passed by the Supreme Court exactly on this regard, my lord, just for court's consideration, nothing else, my lord.
Which one? That the order should be passed the same day.
Yes.
And then, Lord, that it should be communicated by the court itself to the jail authority, Lord.
That they will do. That is already there. That has been circulated to all the High Court.
Yes. That's
already
circulated. As officer of the court.
I need not mention that.
Yes, no. I am only just bringing to the court's knowledge. I am so grateful, my lord, and I apologize to appear on VC, my lord. I am grateful.
Could we get the order, Dasti?
Anything else? There is no.
There are same orders. There are 4 appeals.
In one order, it will come out in one order.
Yes.
I am grateful.
Part 2 hearing item 15.
May it please your lordship.
One more thing, just add. Any observations made in this order shall not be taken to be the final observations of this court at the time of hearing the appeal. That's all, Yes.
Yes, may it please your lordship. This is an appeal against the impugned judgment and order date 17/12/2024 passed by the Court of Civil Judge, Senior Division 1, Aizawl in CMA 462 of 2023 in civil suit number 51 of 2014, whereby the application for setting aside an ex parte order was rejected.
Those judgments that you had given me, I had taken it out and somehow it got lost. It is with regard to, we had heard this matter. Correct? You were the one on the last date. What is this
This
matter?
is different, my lord.
This is different.
Yes, this is an FAO, my lord. FAO, first appeal against order.
You are challenging what?
We are challenging the order passed in CMA number 462 of 2023, whereby the application for setting aside an ex parte order was rejected by the trial court.
Application under section what?
Application
under which provision of law?
The application is at page 14, my lord. This application has been filed under Order 9, Rule 13 CPC for setting aside ex parte judgment, and order dated 13/12/2021, along with the ex parte order dated 23/1/2019, passing the connected civil suit number 51 of 2014. The facts of the case is that, my lord, I am an engineer. I am a supervising engineer working under the PWD, and one person, namely Sujata Chakma, was allotted a contract work. Previously, the original contract work was issued to R. Laldiana, who is the respondent number 5. And he had subletted the contract to Sujata Chakma. And I am the supervising engineer for the said contract work. And this contractor, he had hired the services of the respondent, who is the plaintiff in the suit, by hiring his excavator. And
so you are a SE, you are a superintendent engineer.
No, my lord, I am a junior engineer.
In the
PWD. So I am supervising the contract work. Of construction of road, my lord. Chotapan Suri to...
Who is doing the construction of work?
The construction of work is done by Sujata Chakma, but he is not made a party in the suit.
Okay.
So he had hired the services of the plaintiff, and the plaintiff was under the...
Who had hired the service of the plaintiff?
Sujata Chakma.
Who has filed the case, suit?
The plaintiff, the owner of
Who
the
is the
excavator.
plaintiff? Which one?
The plaintiff is
Lalram
Laram
Machwana or Lalnun Moya? Which one?
Laram Machwana.
Laram Machwana is the plaintiff.
Is the plaintiff.
And you are the defendant.
I am the defendant.
Number 1.
I am the defendant, yes, my lord, in the suit. I am the defendant number 1 in the suit.
Let me see the plaint.
The plaint is at page 26, my lord.
Page 26. Okay, so what did this Lalam Machwana want? What is his prayer?
His prayer is that he should be paid the hiring charges for his excavator.
From all of you?
From all of us, but specifically he had made a statement in his plaint that at paragraph number 5, my lord, page 28, that the defendant number 1, even though being a government servant and prohibited to engage in private businesses connected with his government services by his service and conduct rules, was engaged by the defendant number 2.
And it usually happens also.
But my lord, this is not the case.
Anyway, so this is what they say. So what did the trial court do?
The trial court issued summon on different occasions which I did not receive.
Only you did not receive?
Which I did not receive.
What about the other defendants? Did they receive?
Other defendants?
2 to 6? Did they receive? Were they part of the trial? Yes, were they a part?
Yes, my lord.
My lord,
Did they participate in the suit?
Yes, my lord. However, White order dated 23/01/2019, this is at page number 71. An ex parte order was passed against defendant number 1, 2, 4, and 5.
Page number?
Page number 71. It starts from page number 71 on the last paragraph. Order date 23/1/19. The typed copy is at page 72.
You see, the issue ex parte, it cannot be ex parte. So 2, 3, 4, 5, and 6, did they submit their wakalatnama? Were they represented at one time or the other in the trial court? Or they were there, or they never appeared?
2, 4, and 5 have been unrepresented. 1, 2, 4, and 5, my lord.
No, my lord. No, my lord. 1, 2, 4, and 5. It's recorded that 1, 2, 4, and 5 have been absenting themselves.
1, 2, 4, and 5 were absent all the time.
Yes. So ex parte proceeding was done
against 1, 2, 4, and 5.
Yes.
And what was the order of the court?
The order of the court was that
payment.
My lord.
Payment has to be made by all of them.
No.
defendant.
Defendant, only the
instant
appellant. Defendant
Yes,
number one.
Only by you?
Yes.
Okay. How much?
Rupees 20 lakhs.
20 lakhs. And then, so you challenge that order?
I challenge that order.
By way of this
CMA.
CMA, 462.
Yes, my lord.
And that CMA has been rejected?
Rejected. I filed the CMA only after ascertaining the truth, ascertaining that the fact that Sujata Chakma has obtained all the bills for the contract work. I even submitted the check before the trial court and saying that I never received any amount, even though in spite of the learned trial court acknowledging the fact that Ms. Sujata Chakma was receiving all the contract work, he had refused to entertain my application.
But why didn't you appear before the trial court?
My lord, that I can explain, my lord. I appeared during the COVID period. Once someone was delivered to me, and
so you appeared.
Yes, my lord.
Then where is your where is your defense?
My lord.
Did you submit written statement?
No, my lord. I was not served with a plain copy. I did not even know their claim.
But you were served a notice.
Notice doesn't include anything. Notice said appear
Did
before the court on that date.
Did you go to the court and say that please give me a written copy of the plain? Did you say that?
If I may take your lordship to the court order, my lord, page 79, my lord.
Yes.
Plaintiff is absent. Defendant number 1 appeared in person. Pro forma defendant number 7 to 8 are represented by AGA. After hearing defendant number 1, I feel that personal appearance of the plaintiff and defendant number 1 before the court is necessary. This is 18/2/2020. This is fixed on 9/3/2020. Appearance of the defendant number 1 and the plaintiff. Issue summon to the plaintiff. And on 9/3, that is page 81, my lord. Plaintiff is absent without cause. Defendant number 1 appeared in person. AGA are present. Case cannot be proceeded due to the absence of the plaintiff. Fixed 6/5 for 2020. At 6/5/2020, I believe, my lord, we are already under lockdown, my lord.
You see, on the few occasions that you had appeared in the trial court,
yes,
where is your prayer to the court that you have not been given a copy of the plain?
My lord, I explained that in my grounds of appeal. I've appeared to the court blindly. I don't know anything. I've been served with one summon only saying that you should be present on this court date. And the court informed me that the presence of the plaintiff is necessary. He has not given me anything. So what am I to do, my lord?
Ignorance cannot be an excuse.
My lord, it's not an ignorance. It's the inaction of the plaintiff. He should have served me a copy.
No. But there is nothing to show that you were not served. It is nowhere reflected that you were not given a copy.
It does not reflect that I have been given a copy.
It is expected. It is
believed. Expected, but it is not done so, my lord.
Well, if that is your case, then end of the matter, nothing to say. I can decide the matter now.
No, my lord.
If that is your case, that it is expected that it cannot be proved that I was given a copy. If that is your case, well, we'll dispose of the matter. Very simple. Then
my lord,
you can go to Supreme Court.
If I may take your lordship to page 132, my lord.
I think I've heard
my lord, if my lordship.
Please argue properly. Don't give that type of answer to the court. You've got to be very careful in your choice of words.
Yes, my lord. I apologize, my lord. In my grounds of appeal, I have stated that I have not been given a copy, my lord.
Any grounds of appeal you might have stated. But
and if my lord may kindly turn to page 132, my lord. This will show very clear that I have not received anything, my lord. Page 132 of the appeal. It's the third page from the last, my lord.
Yes.
This is the power of attorney issued by Arlian Tuanga to Sujata Chakma. No all men by this presence that I still Lian Kluang Abungkon. I as all class 1 contractor do hereby nominate, constitute and appoint Miss Sujata Chakma, wife of Mr. Buddha Lila, resident of Kamala Nagar, Longklai District, Mizoram, to be my legal and lawful attorney to do the following things and acts on my behalf. That my attorney is authorized to buy, perform, participating in and execute the contract work, namely construction of Kamala Nagar, Chotapan Suri Road, improvement and widening, group number G.
Who is this Lian Kluanga?
Lian Kluanga, he is the he is the defendant in the suit, my lord. He is the defendant number 3, my lord. He is a contractor. He is a first class contractor, my lord.
No, this matter pertains to what? What is the...
My lord, they have been...
Which contract work are you talking about? How many contract works are involved here?
Only one contract work. Even
only this contract work?
Yes. The plaintiff is not clear, so he has sued all the other contractors. The only person taking up the contract work is the defendant number 3 in the suit. This defendant number 2, 4, 5 and 6 are not necessary. They are not even involved in the contract work. But
so only 3 is involved?
Yes. Since the plaintiff himself is not sure of the facts of the case, he had instituted the suit against all of them. And this contract work has also been mentioned in the plain, my lord.
But it was your duty to tell the court. It's not that no one comes to the court just to have a cup of tea and go back. When a party is made a party, when a person is made a party, he comes to the court for a reason. He tries to understand why is he called to the court. It's not as if you're going on a picnic.
Yes, my lord. That is exactly my prayer, to contest the case on merits.
You pay half the amount.
No, my lord.
You deposit half the amount.
My lord, I am a government servant. If this judgment is allowed to stand, I will be liable for. I will also be liable for criminal cases, my lord.
No, for delay in coming, you deposit half the amount, 50%.
My lord, there is no delay, my lord, in this appeal. There is no delay. We've come in time, my lord. We've come in time. There is no IA, there is nothing. We've come in time, my lord.
Yes, what is your case?
My lord, my case basically is that the instant appellant had hired, if your lordship will come at page number 28, this is the plaintiff in the civil suit. He had hired my earth mover, Komatsu PC 130, at the rate of rupees 3,500 per hour, and the appellant had engaged my earth mover from 4/03/2011 till 27/5/2011 for 716 hours, and the amount payable comes at rupees 25 lakhs 6,000. And your lordship, if I may take your lordship at para number 10, the instant appellant had, out of that 25 lakhs, he had paid me rupees 5 lakhs, which can be seen from page number 59. Page number 59. This is 60 is the true typed copy. My name is reflected at serial number 1. And the signature of the appellant is also, my lord, present at page number 59. It is stated that I am his employees. Now, my lord, during the proceedings of the civil suit, several summonses were issued through the OC site will PS. This is at page number 124. Page number 124. Page number 124, and the signature of the appellant is also there.
No, here appeared.
My lord, that is after, his appearance was after the ex parte order was passed.
Okay, that's after.
Yes.
But this is prior to that.
Yes, prior to the issuance of the ex parte order. And again, my lord, at page number 1.
Let us see the trial court records. When was the ex parte order passed?
23/01/2019.
Ex parte
page
order.
number 71.
ex parte order on
23/01/2019.
2019. And this notice, this summons was served upon him on,
My lord, this was issued on 7/04/2015.
My lord, that we have denied, even comparing the signatures, it's
no,
quite
so
relevant.
let me see something, let me see the court order.
My lord.
The defendant number 1 is also present. 19/5/2015. It is here.
19/5/2015.
Show it to them.
That order is
Entire case goes. You see it also there in that order at the bottom.
The defendant number 1 is also present at the defendant I presented Mr. John. Lord, this I am not aware.
15.
The case goes.
But nevertheless, my lord,
So your entire reason that you were not served, you did not know anything goes.
my lord, one aspect, my lord, this is my main ground of appeal, my lord. If your lordship may kindly allow me to submit just one. If this thing goes, then it goes, my lord. Page 133, my lord, of the memo of appeal.
Yes.
Page 133 is the check issued to Arlian Tuanga, represented by Sujata Chakma. This is the amount for the contract work, my lord. That is the contract for which they are claiming their excavator has been hired, my lord. This has been issued to Sujata Chakma and Arlian Tuanga and not me, my lord.
No, we don't know.
And my lord, I have just one more citation in this regard, my lord.
No, we are on facts. We are not on.
Yes, my lord. This might cover my case, my lord.
Mr.
Just, if your lordship may kindly allow, my lord.
Learned counsel for the learned counsel for the.
My lord, I will be liable
Appellant.
for criminal case as well.
Yes.
So,
Can't help it.
my lord, this just one submission, my lord. Our courts are usually short of time because of huge pendency of cases, and at times the courts arrive at erroneous
Out here you have
conclusion.
told, you are telling a lie to the court.
I'm not telling a lie, my lord. That is
It is here.
My lord, it might be there, but we appeared that we have not hide anything, my lord. Our appearance have also been reflected in our appeal.
No,
my lord.
you might not know, but your client is telling a lie.
My lord, we have not received the amount. So if I am liable to pay, my lord, that would be a grave injustice, my lord. Let me.
I can't help it.
My lord.
It has to come to an end, Mr. Counsel. We cannot allow this. Defendant number 1 is also
Then,
present.
my lord, then let me please allow me to amend my application, because that thing that we have not heard of it before, my lord.
No,
my lord.
Heard, Mr. Zoram Chana, learned counsel for the appellant. Also heard, Mr. Tilal Zakima,
for the respondent number 1, my lord.
counsel for the respondent number 1. Anybody else? Mr.
Zodin Pue Namte.
Rodin Pue Namte appearing for
Respondent number 2, 3, 5 and 6.
2, 3, 5 and 6. Pustak. The
Then, my lord, at least allowed me to withdraw the application, my lord. I will withdraw the appeal.
Mr. Zoram Chana learned counsel for the appellant prays that he may be allowed to withdraw the appeal. Keeping in view the order dated 19/5/2015 passed by the learned trial court in civil suit number 51 of 2014, which states that the defendant number 1 is also present, comma, the prayer of the appellant's counsel is allowed. The appeal is accordingly dismissed as withdrawn.
Just one liberty to challenge the judgment and order on merits.
That you file. That's
Yes.
all you can do. That's
It
all
may
you
be
can.
reflected,
That's
my
all
lord.
you can do. I don't know if the court will allow. There's no.
There's no bar, but, my lord,
There's no
yes.
bar. We cannot say anything on that
Yes,
because you see these facts are here. Acha, send back the case record. Send back the TCR. Finish. You should have checked.
My lord, we have never seen that before, my lord. All the
And I'll tell you
orders
what,
with-
I'll
all-
tell you why it is not a mistake. I'll tell you why it is not a mistake. It says here the defendant number 1 is also present. Court is adjourned. Issue summons to the defendants except the defendant number 1 and number 6.
all the other orders we have enclosed, my lord, that we have missed.
You see, because it has been clarified again in the next sentence that issue summons to the defendant except defendant number 1. You challenge it.
Ah.
You try
So, my
to
lord,
have
at
a
least let it be reflected in the order to challenge the
Too late now.
orders on merits. That's all, my lord. Just for annexing that order in the main appeal.
Huh?
Just so that I will be able to annex the order of today in the main appeal, saying that I may be allowed to challenge the main judgment order on merits. That's all, my lord.
That's right. It is needless to add that the appellant can challenge the impugned
Judgment and order.
judgment and order passed by the learned trial court as per law.
Obliged, my lord.
As per law, but not by way of the
FAO.
but not on the grounds mentioned in this case. But not on the.
I have mentioned one merit, my lord, one ground saying that I have not received any amount. So the grounds will conflict with each other, my lord. Because that ground has to be taken in the main appeal. Because I have not received the amount. That part I have stated in this.
But not on the ground that he was not present.
He was not receiving the summons.
Not on the ground that he had not received the summons issued by the learned trial court.
On merits. Got it, my lord. Obliged, my lord.